Welcome to my channel. If you're planning to sponsor your spouse or family member for a green card in 2026, you need to pay very close attention because the rules have changed significantly, and these changes could make or break your application. Whether you're a U.S. citizen trying to bring your spouse to America, a green card holder navigating family-based immigration, or someone who's already in the process, what I'm about to share with you today could save you months of delays, thousands of dollars, and potentially prevent your application from being denied altogether. The marriage-based green card process has always been complex, but 2026 has brought new regulations, updated income requirements, stricter documentation standards, and enforcement measures that are catching many couples completely off guard. Immigration officials are scrutinizing applications more carefully than ever before, and the margin for error has become razor-thin. I've seen cases where couples who thought they had everything perfectly prepared ended up facing requests for evidence, interviews that lasted hours, and in some cases, outright denials because they weren't aware of these new requirements. So let's get straight into what's changed, what you need to know, and most importantly, how you can protect your application and ensure your family stays together. First, let's talk about the most significant change that's affecting nearly everyone filing an I-130 petition in 2026: the updated financial requirements. The Affidavit of Support, which is Form I-864, has always been a critical component of the marriage green card process, but the income thresholds have been adjusted to reflect current poverty guidelines, and they're higher than many people expect. For a household of two, which would be you and your spouse, you now need to demonstrate an annual income of at least 125% of the federal poverty guideline. For 2026, that means you need to show an income of approximately $25,550 or more, depending on your household size and the state where you live. But here's what's catching people off guard. Immigration officers are now requiring much more extensive proof of ongoing income, not just your most recent tax return. They want to see pay stubs from the last 6 months, employment verification letters on company letterhead, and in many cases, they're even requesting bank statements to verify that your income is consistent and reliable. If you're self-employed, the documentation requirements have become even more demanding. You'll need to provide profit and loss statements, business bank account records, and a comprehensive breakdown of your business income that clearly demonstrates sustainability. What's particularly important to understand is that if your income doesn't meet the required threshold, you have options, but you need to know about them before you file. You can use a joint sponsor, which is someone who is a U.S. citizen or green card holder who agrees to take financial responsibility for your spouse. However, the joint sponsor must also meet the income requirements independently, and they're taking on a legally binding obligation that lasts until your spouse becomes a U.S. citizen, works for 40 qualifying quarters, leaves the United States permanently, or passes away. This is not a decision anyone should take lightly. Another option is to use household income. If other people living in your household are willing to contribute their income and sign Form I-864A, their earnings can be counted toward meeting the financial requirement. However, they must be willing to make their income available to support your spouse, and they'll need to provide all the same documentation that you're providing. Additionally, assets can sometimes be used to supplement income, but the calculation is strict. Assets are divided by 5 for spouses of U.S. citizens and by 3 for spouses of green card holders, and only the resulting amount counts toward the income requirement. Now let's talk about something that's causing serious problems for many couples: the bona fide marriage requirement and the dramatically increased scrutiny around it. Immigration authorities have always needed to be convinced that your marriage is genuine and not entered into solely for immigration benefits, but in 2026, they're taking this to another level entirely. The days of submitting a few wedding photos and joint bank account statements and calling it a day are over. Officers are now looking for a comprehensive narrative of your relationship that includes detailed evidence from every stage. They want to see how you met, how your relationship developed, proof of communication during any periods when you were apart, evidence of visits if you were in a long-distance relationship, and clear documentation of your life together now. This means text message logs, emails, screenshots of video calls with visible dates and times, boarding passes from visits, hotel reservations, and statements from friends and family who can attest to your relationship. The financial intermingling of your lives has become especially important. Joint bank accounts are good, but they want to see actual transaction history showing both partners using the account. Joint lease or mortgage agreements are excellent, but they're also looking for utility bills in both names, joint insurance policies, joint credit cards, and evidence that you're making major life decisions together. If you have children together, that's obviously strong evidence, but even then, they're looking at the totality of the relationship. What many couples don't realize is that social media has become a significant factor in these cases. Immigration officers are increasingly reviewing social media profiles to verify relationship timelines and authenticity. If your social media shows a different relationship status, if there's no evidence of your spouse on your profiles, or if the timeline doesn't match what you've claimed in your application, this can raise serious red flags. You don't need to post every detail of your life online, but glaring inconsistencies between your digital presence and your application can create problems. The interview process has also become more intensive. While not every I-130 application results in an interview, when interviews do occur, officers are asking much more detailed and specific questions. They're separating couples and asking identical questions to see if the answers match. They're asking about daily routines, family members' names and details, future plans, how you celebrate holidays, what side of the bed each person sleeps on, and incredibly specific details about your home and life together. The best way to prepare for this is simple. Live your genuine married life and be able to talk naturally about it. Let's address conditional green cards, because this is another area where confusion abounds. If you've been married for less than 2 years at the time your spouse receives their green card, they'll receive a conditional green card that's valid for 2 years. This isn't a lesser form of green card, but it does require an additional step. Within the 90-day window before the 2-year anniversary of receiving the conditional green card, you must file Form I-751, the petition to remove conditions on residence. This form requires you to prove that you're still married and that the marriage remains genuine. The I-751 process has become significantly more rigorous in 2026. The evidence requirements are similar to the initial I-130 petition, but now they want to see proof covering the entire 2-year conditional period. This means you should be collecting documentation continuously from the moment your spouse receives their conditional green card. Joint tax returns for the years you've been married, evidence of joint assets acquired during the marriage, proof of joint travel, photographs spanning the entire period with dates clearly visible, and affidavits from people who have observed your marriage throughout this time. Failure to file the I-751 on time can result in your spouse automatically losing their green card status and potentially being placed in removal proceedings. The consequences are severe, so mark your calendar well in advance and make sure you file within that 90-day window before the card expires. Processing times are another critical factor that's changed in 2026. While official USCIS estimates vary by service center, many I-130 petitions are currently taking anywhere from 12 to 18 months or longer to process. This is important for planning purposes, especially if your spouse is currently living outside the United States. If your spouse is inside the United States and eligible to adjust status, they may be able to file concurrently, but if they're abroad, they'll need to wait for the I-130 to be approved before moving forward with consular processing. For those whose spouses are outside the United States, Consular processing adds another several months to the timeline after I-130 approval. The National Visa Center will need to process your case. You'll need to submit additional documentation and fees, and then an interview will need to be scheduled at the U.S. Embassy or consulate in your spouse's country. These interviews are being scheduled many months out in most countries, so factor this into your expectations. One crucial piece of advice: do not rely on immigration officials or customer service representatives to tell you what you need. The standards have become so specific and the discretion so broad that you need to over-document everything. If you think you have enough evidence, collect more. If you believe your case is straightforward, prepare as if it's complex. The cost of being thorough on the front end is minimal compared to the cost of a denial or a lengthy request for evidence. Also, be extremely careful about misrepresentation. Any false statements, fraudulent documents, or material omissions can result in permanent bars to immigration benefits. This includes seemingly minor things like incorrect dates, undisclosed previous marriages that were very brief, or failure to mention a spouse's previous immigration violations. Honesty is not just the best policy in immigration cases. It's the only policy that won't potentially destroy your future together. If your financial situation is complicated, if either you or your spouse has any criminal history whatsoever, if there have been previous immigration violations, if either of you has been married multiple times before, or if there's anything at all unusual about your case, consulting with a qualified immigration attorney is not just advisable, it's essential. The immigration system is unforgiving of mistakes, and having professional guidance can be the difference between success and years of separation. Finally, stay informed and stay organized. Immigration law and policy can change rapidly, and what's true today might be different tomorrow. Keep copies of absolutely everything you submit. Maintain a detailed timeline of your case, save all correspondence with USCIS, and track your case status regularly through your online account. If you receive any requests for additional evidence, respond promptly and thoroughly. If your address changes, update it immediately with USCIS using Form AR-11. The marriage green card process in 2026 is more demanding than ever before, but it's absolutely achievable if you're prepared, thorough, and genuine. The key is understanding that immigration officials are looking for the truth about your relationship, and if your marriage is real, you simply need to document it comprehensively. Don't cut corners, don't assume anything, and don't underestimate the importance of meeting every requirement completely. Your family's future depends on getting this right, so take the time to do it properly. Gather your evidence meticulously, meet all the financial requirements, be prepared for a thorough interview process, and understand the conditional residence period if it applies to you. With proper preparation and attention to detail, you can navigate these new rules successfully and bring your family together in the United States. Remember, this process is challenging, but thousands of couples successfully complete it every year, and with the right approach, you can too. If you found this information helpful, make sure to subscribe for more updates on immigration law and policy changes. Your journey to building your life together in America starts with being informed and prepared, and I'm here to help you every step of the way.